Hey y'all, it's Kim. So this is a lawsuit that was filed, I guess, by Virginia Giuffre in the Southern District of New York against Prince Andrew, the Duke of York, in his personal capacity, also known as Andrew Albert Christian Edward. It said the date it was filed was January 12th, 2020. 2022. It's not a very good copy. I mean, there's stuff in here that doesn't look good. I don't know if it's because they took stuff out, but anyway, we'll just get through what we can and see where we can go from here. But anyway, opinion, appearances, David Boy, something, I don't know. Sigrid McCauley, Andrew Via Caston, Erica Nyborg, Birch, Sabina Mariella, Bowles, Schiller, Flexner, LLP, attorneys for the plaintiff, Andrew B. Bretler, Melissa Y. Lerner, and Lavely, and Insker, I don't know, PC, attorneys for the defendant, the table of contents at facts 2, the Epstein sex trafficking scheme, defendant's relationship with Epstein and Maxwell. Epstein recruits plaintiff, defendant's alleged sexual abuse, the Florida state prosecution and the federal non-prosecution agreement, Ms. Giuffre's Florida suit against Epstein and the federal criminal case against Epstein in the 2009 agreement, discussion dismissal on the basis of the 2009 agreement is not justified on this motion, legal principles, materials properly considered, governing law, analysis of the 2009 agreement, and let's see whether the defendant is among the purportedly released persons, whether defendant is entitled to enforce the release as a third-party beneficiary of the 2009 agreement, relevant provisions of the agreement, defendant's cases are in opposite. What is that? I don't know. The Dershowitz argument. The complaint states legally sufficient claims, legal principles, analysis. The complaint is legally sufficient. Defendant's contention that the plaintiff was obliged to plead specific facts demonstrating violation of the New York penal law is incorrect, and plaintiff's IED, whatever, and battery claims are not duplicative. The attack on the constitutionality of the New York Child Victims Act is without merit. The defendant is not entitled to a more definite statement. He will get the detail he seeks during discovery. In the conclusion, Lewis A. Kaplan, district judge, plaintiff Virginia Roberts Giuffre, brings this action against defendant Prince Andrew, Duke of York, for battery and intentional infliction of emotional distress. In short, she alleges, well, something's been redacted, that the late Jeffrey Epstein and others trafficked her to Prince Andrew, who took advantage of the situation by sexually abusing her when she was under the age of 18. Defendant denies Ms. Giuffre's allegations and attacks her credibility and motives. He asserts that she was complicit in Epstein's unlawful activities, but this is a motion to dismiss. Ms. Giuffre's complaint is legally insufficient not to determine the truth or falsity of charges in her complaint. See, I don't know why it's written like this and it's separated. So that's why I say it's a bad copy, but I don't know why it wouldn't be like legit. So that's reading through it. Hopefully that makes sense. Yeah, if normally it wouldn't look this way. But anyways, this and defendant relies mainly, although not exclusively, on a 2009 agreement between Ms. Giuffre and Epstein that settled a different lawsuit between Giuffre and Epstein that defendant now argues released him from any liability to Ms. Giuffre. The fact that the defendant has brought the matter before the court on a motion to dismiss the complaint as legally insufficient is of central importance, as is well something, I don't know what that is, as is well something to lawyers, but perhaps not known. Oh, okay, they screwed up. As is well known is what that should be to lawyers, but perhaps not known to the lay public, the defendant making this motion placed upon the court the unyielding duty to assume, for the purposes of this motion only, the truth of all of plaintiff's allegations and to draw in plaintiff's favor all inferences that reasonably may be drawn from those allegations. In consequence, the law prohibits the court from considering at this stage of the proceedings defendant's efforts to cast doubt on the truth of Ms. Giuffre's allegations, even though his efforts would be permissible at a trial. In a similar vein and for similar reasons, it is not open to the court now to decide as a matter of fact just what the parties to the release in the 2009 settlement agreement signed by Ms. Giuffre and Jeffrey Epstein actually meant, as well appear more fully below something the cutouts job, I don't know, or court's job at this juncture is simply to determine whether there are two or more reasonable interpretations of the document. If there are, the determination of the right or facts, I don't know, controlling interpretation must await further proceedings. That's why I say this is terrible copy. Except as otherwise noted, the facts are drawn from Ms. Giuffre's complaint. It bears repeating that its allegations are deemed true for purposes of this motion, whatever a trier of fact ultimately might determine a trial. Okay, the Epstein trafficking scheme. Plaintiff's allegations arise principally from a sex trafficking scheme orchestrated by the late sex offender Jeffrey Epstein, which by now has been publicized widely. According to Ms. Giuffre's complaint, Epstein sexually abused more than 30 girls, 30 minor girls in the United States and overseas from between 1999 and 2007 in concert with paid employees and others, notably Ghislaine Maxwell, who recently was convicted in this district of sex trafficking in connection with the Epstein events. Epstein and others lured vulnerable young girls into a scheme of abuse for Epstein's own sexual gratification and for that of some of his powerful and wealthy friends. Let's see. I'm just trying to see Jane Doe. And then, yeah. Epstein relied on Maxwell and others to identify and target vulnerable young girls in numerous settings, including schools, spas, trailer parks, and the street. Epstein's recruiters lured these girls into his orbit with the promise of what appeared to be legitimate masseuse positions. Once manipulated into returning to one of Epstein's residences, however, the girls were groomed for abuse by Epstein and others, through displays of wealth, power, and sexual imagery. Once initial sexual abuse had occurred, Epstein and Maxwell further manipulated the victims with a combination of promises, threats, and surveillance. At its height, Epstein's sexual abuse scheme, managed principally by Maxwell, was transcontinental. Using his private jet, Epstein trafficked dozens of minors for sexual abuse at his New York City mansion, his New Mexico ranch, his private island in the U.S. Virgin Islands, his Palm Beach, Florida estate, and elsewhere. 2008, he pleaded guilty in Florida to procuring a minor for prostitution. Defendant's relationship with Epstein and Maxwell. Again, according to Ms. Giuffre's complaint, the defendant first met Epstein in 1999 through the former close friends, Ghislaine Maxwell. Over the next several years, the defendant traveled with Epstein and Maxwell on Epstein's private plane and was a guest at Epstein's numerous homes, including the private island in the U.S. Virgin Islands, Little St. James, and properties in Palm Beach and New York City. Epstein and Maxwell were guests at the defendant's 40th birthday party in 2000, as well as at a birthday party that the defendant threw for Maxwell in Sandringham, United Kingdom, in the same year. In 2006, 1 month after Florida state prosecutors, defendant's daughters, what? Something was redacted there. As recently as 2010, and therefore after Epstein had done jail time in connection with the 2006 Florida charges and registered as a sex offender, the defendant was photographed with Epstein and stayed at Epstein's New York City mansion. In 2006, 1 month after Florida state prosecutors charged Epstein with procuring a minor for prostitution, the defendant invited Epstein to the 18th birthday party. Okay, so they screwed this all up. Okay, so something about 18th birthday party of one of his daughters, which was up there. I don't know why the hell this is all messed up, but anyway, hopefully it's a true and accurate record, but it sounds plausible. It sounds correct to me. I don't know. I'm just saying. So Epstein recruits plaintiff. So Miss Giuffre's complaint continues. Maxwell recruited Miss Giuffre into Epstein's sex trafficking activities in 2000 when Miss Giuffre was 16 years old and employed at the Mar-a-Lago Club in Palm Beach. Like other minor girls whom Epstein and Maxwell targeted, plaintiff initially was recruited to provide massages and thereafter to engage in a variety of sexual acts for Epstein. From 2000 through 2002, plaintiff traveled frequently with Epstein, both within the United States and internationally, on his private plane. In addition to being on call for Epstein for sexual purposes, plaintiff on other occasions was lent out to other powerful men, including the defendant. Defendant's alleged sexual abuse. The complaint alleges, and the court, for present purposes, is obliged to accept that the defendant sexually abused Miss Giuffre when she was under the age of 18 years old. On one occasion, defendant allegedly forced plaintiff to have sex with him against her will at Maxwell's home in London. Miss Giuffre's complaint includes a reproduction of a now widely published photograph of Miss Giuffre, Prince Andrew, and Maxwell at Maxwell's home, which plaintiff says was taken prior to that event. On another occasion, defendant allegedly abused Miss Giuffre during a visit to Epstein's private island, Little St. James. Miss Giuffre alleges that the defendant abused her at Epstein's mansion at the Upper East Side of Manhattan, which lies within this judicial district. During that particular encounter, Maxwell forced plaintiff, a child, and another victim to sit on Prince Andrew's lap as Prince Andrew touched her. During this visit to New York, according to the complaint, the defendant forced Miss Giuffre to engage in sex acts against her will and was aware both of her age and that she was coerced. She was a coerced sex trafficking victim. In each of these encounters, plaintiff alleges Epstein, Maxwell, and the defendant compelled her to engage in sexual acts by expressed or implied threat. In consequence, plaintiff feared, death or physical injury to herself or another, among other repercussions if she disobeyed. Ms. Giuffre asserts that the defendant's actions caused and continue to cause her significant emotional and psychological distress and harm. The Florida state prosecution and the federal non-prosecution agreement. At this point, it is helpful and appropriate to refer to facts not alleged in the complaint in this case, but of which the courts take judicial notice. In July 2006, the Florida state grand jury indicted Epstein in a state court on account of federal solicitation of prostitution, the Florida state indictment, as will appear that charge remained pending until mid-2008. As previously noted, defendant's motion in this case relies heavily on the 2009 agreement between Epstein and Ms. Giuffre, which already is before the court as a matter of judicial notice. The 2009 agreement contains the following paragraph. The court takes judicial notice only to the extent of the facts set forth in this section of this opinion, and in the case of documents, for the existence or contents of the documents, but not the truth of assertions the documents contain. And then whatever this is. And then indictment, state versus Epstein, number 0694554, CF, Florida Circuit, July 19th, 2006. Reprinted in U.S. Department of Justice, Office of Professional Responsibility, report investigation into the U.S. Attorney's Office for the Southern District of Florida's resolution. It's 2006 to 2008 federal criminal investigation of Jeffrey Epstein and its interactions with victims during the investigation. Example, I guess one is November 2020. The OPR report contains a great deal of information about how the NPA came to pass, the non-prosecution agreement, but the court does not take judicial notice of its statements or consider it in deciding this motion. Okay, first and second parties further stipulate and agree that this settlement agreement is pursuant to and is in fulfillment of Jeffrey Epstein's obligations to Virginia Roberts Giuffre, pursuant to and in conformity with the non-prosecution agreement, its addendum, and its affirmation between Jeffrey Epstein, United States Attorney for the Southern District of Florida. Thus, the terms of the non-prosecution agreement of the NPA may shed light on the meaning of the 2009 agreement. The court therefore takes judicial notice of the NPA, its addendums, and affirmation. For present purposes, the following terms of the NPA are of possible interest here. Epstein agreed to plead guilty to the Florida state indictment and to state information charging him with solicitation of minors to engage in prostitution. The U.S. Attorney's Office agreed to provide Epstein's attorneys with a list of individuals whom it had identified as victims as defined in 18 U.S.C. 2255 and in consultation with and subject to the good faith approval of Epstein's counsel, would select an attorney representative for these persons who would be paid for by Epstein. Epstein's lawyers, could contact the identified individuals through that representative. And then this is probably just a footnote about that. Okay. So Epstein agreed that if one or more of the individuals whom the government had identified as victims elected to sue Epstein under 18 U.S.C. 2255, Epstein would not contest jurisdiction over him in the Florida federal court, and he would waive his right to contest his liability. In addition, he would waive his right to contest damages up to an amount as agreed to between the identified individual and Epstein, so long as the identified individual elected to proceed exclusively under 18 U.S.C. 2255 and agreed to waive any other claim for damages, whether pursuant to state, federal, or common law. Epstein's waivers, however, would not apply to anyone who had not been identified by the government as a victim or having been so identified did not proceed exclusively under 18 U.S.C. 2255. Okay, so it says the U.S. Attorney's Office agreed that it would not prosecute Epstein nor institute any criminal charges against any potential, look at this, any potential co-conspirators Epstein, including but not limited to 4 specifically identified persons, if Epstein pleaded guilty to the Florida charges and otherwise discharged his obligations of the NPA. So the NPA bears signatures dated variously in late September and in October. Ms. Giuffre's complaint alleges that Epstein pled guilty to the Florida information. I don't know what they're trying to say here, and presumably the indictment in 2008. Okay, So this is all screwed up, but it says May 2009, while Epstein was incarcerated in Palm Beach County, Florida, as a result of his guilty plea to the Florida state charges, Miss Giuffre sued Epstein in United States District Court for the Southern District of Florida in the Florida case under 18 USC 2255 as an alleged victim of Epstein's alleged federal sex trafficking, sexual exploitation, and child pornography. What the hell? Why is this all messed up? Anyway, something about royalty. That's all I can see. Whatever they screwed that up. Politicians. What? Businessmen and other professional and personal acquaintances had sexually exploited her. Miss Giuffre and Epstein entered into the 2009 agreement, entitled Settlement Agreement and General Release, pursuant to which Giuffre voluntarily dismissed her action against Epstein in exchange for $500,000. The defendant argues that Miss Giuffre's claims against him are barred by the terms of the 2009 agreement. The federal criminal case against Epstein. On July 2nd, 2019, a grand jury in this district indicted Epstein for alleged sex trafficking conspiracy and the substantive crime of sex trafficking in violation of 18 USC 1591. Hold on, something about. Okay, so he was arrested, I guess, on the 6th of July. They've got this all messed up. And then in August, probably 2019, it was found dead in his cell at the Metropolitan Correctional Center. So, anyway, I don't know why this is all messed up, but I mean, a lot of this sounds like the correct timeline. So that's why I'm just kind of like leaving it there. Let me stop here. I'll keep going and we'll try to get through this all today. But anyway, talk to y'all later. Bye.